The weather outside is frightful, and the radiator has stopped working, so my nose is going to remain really red. The question today is, are PMCs legal? And I really despise people who decide to prolong the answer to really straightforward questions. Are PMCs legal? In short, yeah, internationally they are. And that's how they're allowed to continue to exist. The end. Yet, unfortunately, it's far more complex than that. Much more complex. I have been researching this for about a month now. Pretty much every day. For about half an hour. It's ridiculously complicated. So in this video, I'm going to do my best to give a basic overview. And I'll start where the majority of people do tend to start. With the legalities of war based upon the Geneva Conventions. Why am I starting here? Well, the fact of the matter is, PMC's legality is complex. Because when we're dealing with certain nations, they each have certain laws. Each region has certain laws. Each continent has certain laws. There are certain bilateral agreements that a lot of countries don't hold to, that a lot of countries don't hold to in practice. Particularly in the nations that PMCs operate in, which are by definition probably in some sort of conflict. Governments chop and change. Legislation chops and change. Can we view this legislation as legitimate? Can we say that this government has a right to comment on whether PMCs are legal, on whether they're okay? Can we say that a certain government has sovereignty, has the ability to override old laws, international laws? There are certain nations that have laws that are really outdated. There are certain nations that have brought new laws in but haven't gotten rid of the old ones. There are certain nations that have brought in new laws, but those new laws aren't necessarily legitimate. The problem is, it's really, really complex. And war lawyers acknowledge this, and this is largely what they debate. Whether we can, I guess, find a balance in between where these, I guess, certain agreements, certain laws can find the equilibrium. And generally the equilibrium, the overall consensus is the Geneva Conventions is where you find that, because it's, a large, so probably the most all-encompassing bilateral agreement to the modern day. And if we're looking at it on an international law scale, that's probably the best basis on which to build our argument of whether they're legal or not. Again, the Geneva Conventions, pretty all-encompassing, bilateral agreement that a lot of countries are party to, modern, based upon ethics found in the Second World War, developed since really 1864 by the Red Cross, so it doesn't miss out a huge amount. But there are still a number of gaping holes, a lot of people think. The Geneva Conventions are really important for PMCs, because one needs to distinguish, as an initial basis, what are PMCs? And the initial basis for this generally is, are private military contractors combatants or non-combatants? Because that will determine their rights during wartime. And because, of course, the Geneva Conventions themselves don't actually outline whether private military corporations as firms are legal, whether they're okay. It doesn't dictate that at all. But what it does say is the certain rights given to combatants and to non-combatants. Now, are they combatants or non-combatants? The general consensus, if one is to say there is general consensus, which there never is on this sort of stuff, is that PMCs are civilians with authorization to accompany forces in the field, and as such, they take on a large number, if not all, civilian protections. And probably the most important of those is that it's illegal for them to be the subject of intentional military attack. You can't attack them as a force specifically, but the military that they are supporting is still combatant, so you can attack them. For your classical PMC, the one that delivers food, ensures that water's clean, they may be armed. That may depend, and that may change their status, and they may be, have something to defend themselves. But those sorts of PMCs that operate purely based upon civilian-based services, or non-violent services, as it were, that don't require active action, as it were, those firms are civilians. They're not combatants. And so if we're looking at this classical PMC, it supports, or it doesn't support, direct military operations. Therefore, it is civilian. Now, if we are to say that these firms are civilian because they don't support direct military operations, then the ones that do, the ones that operated during the 70s and 80s, they lose their legal protection as civilians. They act as combatants, the sort of ones we might have seen in Afghanistan, in Iraq. And then they act as combatants, they lose their rights as civilians, they gain their rights as combatants, and of course they can be attacked directly. Now, people aren't necessarily clear on this, but I think largely, if there is a consensus, it says that this is anything that involves active military conflict in the promotion of hostilities. This could be guarding a base from attack, from carrying weapons systems at all. Even non-violently gathering information counts. So it's a very quick transition from civilian to combatant for the constituents of these firms. What can we glean from this? Well, I'd say that first, firms that aren't actively participating in hostilities, firms which are the majority of them, which are participating in, we'll call them civilian services, are civilians. We can limit combatant status to those in an active war zone engaging in the promotion of active hostilities, generally via assault or defense. And very few of these actually exist proportionally. Even, private military corporations that exist at home. And it has to be with a recognized conflict party, as it were. And that's generally a state. So if you're doing this against a paramilitary organization, the lines are blurred again, because there's not necessarily such clear definition as what a combatant is, of what rights one has, because paramilitary organizations don't necessarily meet the requirements to act as certain parties themselves. Now, a lot of you may be thinking right now, well, does that really exempt other firms that aren't actively involved in strategic or tactical movements? These ones that we might classify as civilians. Does it exempt them from certain laws? Well, the answer is no. That is to say the positive. Civilians can still commit war crimes, of course. They're still culpable in all sorts of ways. It's just that there is, for the enemy, an intensified limitation on enemy engagement with them. So, being legal civilians doesn't mean that they can do whatever they want. It doesn't mean that they can be used as a vessel for national militaries to do stuff that the military wouldn't have equal protections for as a combatant organization. Their status changes based upon their actions. They can't get away with anything. Being civilian can change. Being civilian doesn't exempt one from the Geneva Convention's rules. That means that legally, they may be culpable if captured. And if they're participating in hostilities in an active manner, they can be tried for that participation, and they'll be tried as combatants. And this is largely how the consensus of humanitarian boards for PMCs actually, work, how they are viewed, how they should be dealt with. And that's generally on a case-by-case basis, dependent upon their actions. They can change from civilians to combatants very, very quickly, and they think most humanitarian legal boards think that they should be viewed in that manner, on this case-by-case basis. And civilians, of course, have certain rights, combatants have certain rights, and it should be treated with that sort of respect. You can't put a blanket over the top of this entire thing. Now, people often say, okay, so let's say we have this firm here, which is a civilian PMC, and this one here, which engages in combatant PMC. Does that actually mean they're legal? The civilian PMC, certainly, because they are civilians. They're not engaged in anything illegal. Potentially, they're not engaged in anything that might go against national agreements, unless it is sort of a national agreement of the state that is being warred in, as it were, that doesn't allow certain nations certain rights. But generally within war, that falls away a little bit. In any case, for this PMC over here, the one that is certainly combatant, the one that might be defending a base, the one that might be The question is, are those mercenaries? Because that would be the main blow. If they are mercenaries, they are legal. The Geneva Conventions do not allow for mercenaries at all. UK citizens also, of course, cannot be mercenaries under the Foreign Enlistment Acts of 1819 and 1870. And what these acts say is that for British citizens, if you're a British subject or citizen, to join the armed forces of any state warring against another state at peace with Britain is illegal. I.e., if the UK isn't at war with a nation or an organisation, you can't join another armed forces of a foreign nation that is fighting against them. And this actually seems to directly contradict some firms fighting in the 70s and 80s in Africa. So it might class them as PMCs because they are, I guess, a lot of them British citizens, and they are fighting against, the organisation is owned by British citizens, and they're fighting against nations which the UK is not at war with. What you might also notice is that this exempts certain PMCs as being mercenaries. So the Geneva Conventions lay out certain specific criteria for being a mercenary, but in regard to UK law, this would mean that those PMCs operating in Afghanistan or Iraq to aid Britain or America or any ally of the UK would be legal because they'd be operating within a certain war zone that the UK is involved in, meaning that the UK is at a state of war with those nations. So that's important. Now you might be saying, well, it's simple then. The firms in the 70s and 80s which engaged with countries that the UK was not at war with are illegal. I knew it, they're evil. Hold your horses. The Geneva Conventions say that a mercenary cannot be someone who is of the nationality of one of the nations in conflict. What does that mean? It means that if I am, let's say, in the Democratic Republic of Congo, I'm a citizen of the Democratic Republic of Congo, and there's a civil war going on. I cannot be a mercenary, no matter what I do, no matter the action I take. I can be civilian or combatant, but I cannot be mercenary. And this actually exempts a lot of the PMCs in the 70s and 80s from being classified as mercenaries, because they weren't involved necessarily in active fighting. They were involved in training, in legitimate national armies, or even differentiating armies. They're from the warring nation, and that's the entire point. If I go to a nation, let's say the Democratic Republic of Congo, and I train up a load of men who are there, or I consult, I might not be from that nation, but they are, meaning they cannot be mercenaries, and by extension, my training of them means I am not a mercenary myself, because I am not actively promoting hostility through my own action. And again, it's a firm, so its action differs from the individual. It's judged on the basis of the individual, not of the firm. And so any actions really taken, unless there is someone, let's say it's sole tradership, there is someone's name actively tied to it, and a lot of cases with PMCs, they're in Bermuda or something. You can't necessarily tie a name. So in the majority of cases, I think we can say that firms are not necessarily culpable as mercenaries. And the second basis for them being mercenaries that you could possibly catch them on is that they were entering combat for private gain. Now that again is difficult because the definition is hazy. It can be difficult in these situations to say with any real specificity of the intention of what these firms are, because you can't necessarily speak to that. In many cases, their aims are demonstrably not for private gain, but for other reasons: ideology, patriotism, loads of stuff. Call it what you want. It isn't always cut and dry. So are PMCs mercenaries? Probably not. There are very, very few PMCs that fall into that specific category. And let's say that there were some that fell into this category. Beyond this, even if they did fall into this category, they were doing it for private gain. They weren't a citizen of the nation. They were actively participating in the conflict as an individual. They might still not be legally culpable, or at least brought to justice, as it were, or even be in the wrong, because it's the burden of the state of operation, the nation of operation, that is required to prosecute. So if they are mercenaries and they are doing things that are illegal, it is the burden of the nation which they are operating in, which is generally a war zone, to prosecute them. Meaning that if PMCs are operating in an active war zone, the nation that might be prosecuting them generally has other priorities, generally winning a big war. Let's say we have a British PMC. The government, the British government that is, has a number of rights, but that is not necessarily one of them. It can prosecute for lack of compliance with the Geneva Conventions, or any war crimes for that matter. But if I am a mercenary, likely there is no legal case for my prosecution unless it directly affects the UK, or the UK Armed Forces in a negative manner. So are they mercenaries? In nearly all cases, even if they're active combat, no. The UK has also specifically said that in amendments to the 2001 Private Security Act, the aim of the government, the UK government, is to promote high standards for PMCs, perhaps even a certification for PMCs. But that does mean that they're not legal in the UK, even to register. A lot have been registered in the UK. They are by definition business entities, and also they don't seem to be illegal under any application or enforceable law by the FCA, Britain's Financial Conduct Authority. So regulation, let's say, largely falls upon not the nation, not the PMC itself, but let's say the organisation, generally the, let's say, Ministry of Defence that's employing them. And in that situation, regulation largely falls upon the nation that's hiring the PMC, dictating that they can't employ foreign national PMCs. If I'm British, I can't employ a Brazilian PMC, or at least I can't do it myself. They would have to use a domestic PMC, even as a through route. So the question is, where does legality lie? If PMCs aren't culpable by the Geneva Convention, if they're not culpable by UK law, if they're not culpable by national law in a lot of cases because it is a war zone, where does legality lie? And generally, in the legally binding contract that PMCs sign when working with nations, that's where the majority of legal burden lies. They are bound to certain rules, generally on par, if not above, the shining standard of conduct of the national military. For Western nations, that is, particularly the UK, and limitations on what force they can use, the powers they have, as well as the dictation of terms of interaction between the nation employer and the firm contractor, are dictated in this document. So the question is, if legality doesn't lie in the Geneva Convention saying that PMCs aren't okay, if national laws in the UK and the nation of operation say that in nearly all circumstances they are acceptable, particularly if the UK is at war with them and employing a certain firm for that, legality and legal burden lies in the contract that is signed. Now, is that too free? Is that too unregulated? A lot of opinions on that, but the fact of the matter is, for Western nations, for the UK specifically, the contract, requirements are hugely high, very, very high. And through this, there are a lot of very high standards enforced. And of course, they are still bound by the Geneva Convention and Geneva Conventions and whatever UK laws are applicable. Are PMCs legal? In long, or actually still in short. Are PMCs legal? Internationally, yeah. In the UK, in the majority of cases, yes. Operating in a certain nation, maybe. Likely, yes. Are they ethically okay? Well, we'll discuss that at a later date. But legally, generally, they're fine.